On the 19th of March 2021, the Supreme Court of the United Kingdom handed down its judgment in Tomlinson-Blake and Mencap, ruling that sleep-in care workers were not entitled to the minimum wage during their shift unless they were both awake and working for their employer. It's a controversial judgment. My good friend and leading employment law trainer Darren Newman immediately put out a webinar explaining the decision. He said I can reproduce it, so here it is. It was done via Zoom. The quality's not great, but the content is fantastic.
Well, hello everybody. Thank you for joining me. My name's Darren Newman. Welcome to this webinar on the Supreme Court on sleepover shifts. I'm superstitious when I do my own webinars. I always worry that I've left my microphone on mute or something like that. So can someone put their hand up just to show that they can hear me? Yeah, excellent. Loads of people put their hand up. That's great. If I had enough self-confidence, I'd just go ahead blithely assured that I'd done everything right, but I just need to check. So yes, welcome to this webinar. I'm going to be looking at the Supreme Court decision in Royal Mencap Society against Tomlinson-Blake, Shannon against Rampersad. It's a case that we've been waiting for over a year now. And of course, the main reason it's been delayed is very sadly, Lord Kerr, who was one of the justices, died in December last year while he was working on the judgment. And I hadn't fully appreciated until I watched the arguments in this case, preparing for this just a couple of days ago, that Lord Kerr was actually the justice who presided over this hearing. So he was essentially chairing it. And I must say as well that you do get a sense of an incredibly courteous and nice man when you see how he does go about chairing it. So it's very sad that he died. But as a result of that, another of the justices had to take up the duty of writing the leading judgment. That was Lady Arden. And that's why it's taken so long to get to this particular decision. I know from the people who have come to this webinar that there are going to be lots of people who are very disappointed with the result and are personally affected by the result as well. And there are going to be other people on this webinar who are relieved at what the result is because of the impact that would have on their business. I'm going to try not to let my prejudice, I do have some prejudice on this, but I'm going to try not to let my prejudice show too much. I imagine you'll figure out what it is. But I'm going to try my best to just give a straight bat explanation of what's happened, what the argument's about, and what I think this decision means. One of the things I did like about the way Lady Arden gave her summary, if you watch that on the Supreme Court Live website, was that she told you right at the beginning what the outcome was. I don't like it when they leave you hanging for sort of 5 or 10 minutes before they tell you what the outcome is. They describe the various reasoning. So just in case anyone doesn't know, let's start with the headlines straight off. The employees lost, the employers won. And the central principle that's established in this case is that the hours that are worked in a sleepover shift don't count towards the national minimum wage calculation, except for those hours when the worker is awake for the purposes of working. And that means awake and actively performing your duties. It's not about whether you're actually working. It's not about whether you're at your employer's disposal. And this is a very technical distinction that's drawn. I think the Supreme Court was keen to say they're not claiming that people who are working a sleepover shift aren't working. They're simply saying that the work that they do happens not to count for the purposes of the national minimum wage. If you feel that that's an exception without a difference, well, I think that's probably an understandable point of view to take, but that's the way the Supreme Court have pitched it. Before I get into the detail, I should say I'm very happy to take questions over the course of this webinar. There is a Q&A box that you can type your questions into. So do feel free to do that. I'm going to set it so that you can see the questions that other people have asked. So don't necessarily repeat them, but if you've got a question, then put your question in the Q&A, but I'm going to take them at the end if that's okay. I genuinely don't know how long I'm going to talk. I scheduled this for an hour, but I've literally just read the judgment and figured out what I need to say about it, and I haven't timed how long it takes me to say it. So I'll take up as much time as I can answering questions if anybody's got any towards the end. So what is the case all about? Well, there are two cases. There's Mencap against Tomlinson-Blake and there's Shannon and Rampersad. And it's worth setting out what the facts are of each case as they were put by the Supreme Court. Now, again, if there's anyone listening who knows any of the parties involved, they may think that this is an unfair view of what the facts are, or it doesn't give the complete picture. And that may be true, but these are the facts that have come to the Supreme Court. So by the time the case gets to the Supreme Court, the facts have been decided by the tribunal. There's an agreed statement of them that the Supreme Court is working with. So I'm just setting out what the Supreme Court has said the facts are. Ms. Tomlinson-Blake was employed as part of a team providing 24-hour care to 2 vulnerable adults in their own home. So she's not working in a care home per se, she's working in someone else's home. She provides daycare, so during the day she works and she gets a salary for that. And this case is not concerned with her salary, except insofar as it goes towards the overall calculation. But she also did a sleep-in shift on a rota basis that was specified hours overnight. And for the purposes of the national minimum wage, we'd say that that's time work. She's paid by reference to the time she works. But she's not paid the minimum wage for that time. She's instead paid an allowance. During that time, during that overnight shift, she is permitted to sleep, but she's required to remain at the home. So she's to that extent under the control of the employer. And the way she put it was she has to keep a listening ear out. And I think what I take from that is that it's not necessarily a good night's sleep. That just, you know, if you know that you're going to be asleep, but you can easily be woken up and disturbed, then that affects the kind of sleep that you have. But I think what the Supreme Court paid more attention to was that in the period of 16 months leading up to the tribunal hearing, she'd only been disturbed about 6 times. So the assumption was in her work that she would sleep through the night and on rare occasions would be disturbed. And that's relatively important to the overall context of what the Supreme Court has said. She gets an allowance of £22.35 per hour. She also got a 1 hour sort of nominal payment of £6.70, which reflected the minimum wage in 2015 when this case was sort of crystallized. And that means she gets a total payment for each sleep-in shift of £29.05. If she actually works, if she actually had to do work as a result, then any work would be paid at normal rates of pay. The Shannon case is a bit more unusual. And I'm not completely happy with the idea that this was in front of the Supreme Court, to be honest, because I don't think that the facts of the case necessarily create as much sympathy as perhaps the other case does. We have an on-call night care assistant at a residential care home, and he was employed, and I'd almost put that in inverted commas, because he had an arrangement with a friend of his who gave him free accommodation above the home that he was operating, and gave him a payment of £50 a week, eventually £90 a week, on the condition that he stayed in the home from 10 p.m. to 7 a.m. And would be called upon if needed. So if he was needed to provide assistance to people actually working in the care home, he would be called upon. In practice, that very rarely happened. But then there was a TUPE transfer, and instead of the employer being a friend of his, the employer was someone that he eventually fell out with, and he was dismissed in 2014. And he turns around and claims arrears of pay going back to 1993 of £240,000. And it wasn't until after the TUPE transfer that he particularly raised the issue that he wasn't being paid enough. Now, I have to say, to my mind, he was never going to win this case. And it was just a question of how we would make sure that the law was framed in such a way that he wouldn't. So I'm not entirely sure it helped to have him in the frame, but nevertheless, he's entitled to argue the point. And probably it wouldn't have made that much difference, bearing in mind what the Supreme Court say about Tomlinson-Blake. What the case is ultimately about is this regulation. And I apologize for just putting the raw material of the legislation in front of you. That's not good PowerPoint technique, but that's what we've got to work with. And it's about, I've put up the bit on time work. There's an equivalent provision on salaried hours work, which is also there. And it's phrased slightly differently, but it's roughly to the same effect. So I'm just going to concentrate on this provision on Regulation 32. And it says, first of all, that time work includes hours where a worker is available and required to be available at or near a place of work for the purposes of working, unless the worker is at home. So what that's saying is, If you're just required to be available, if you're essentially on standby, let's call it standby, but I require you to be on standby at the workplace, then we're going to treat that as working time. We're going to deem that to be working time. Then we've got paragraph 2, and that says, but the hours when a worker is available only includes hours when the worker is awake for the purposes of working. And that's even if if there's an arrangement that they would sleep at or near the place of work. So if you're asleep in this exception, if you're given facilities to sleep under this section, then that time will not count as being work. So we've deemed some time to be working time, when you might otherwise be regarded as just being on standby. And then we've said, but we're not deeming it to be working time if you are asleep. We're only deeming it to be working time if you're awake for the purposes of working, and an equivalent provision for salaried hours work. Now, I've put it in that particular way because that reflects the way the case law had dealt with that particular exception up until the Court of Appeal in these cases. So the previous case law had said that this sleepover exception, if we call it that, only applies to workers when they're on standby and available for work. It doesn't apply when they're actually working, because if they're already working, we don't need to deem them to be working. We only need to deem them to be working if they would otherwise be on standby. Does that make sense? So the idea would be, if I've got you on standby, we're going to pretend that you're working, but that won't count if you're asleep. But if what you're doing is actually work, if being in the workplace is the very thing that you are being employed to do, then you're not on standby, you're actually working. So Regulation 32 doesn't apply at all. And that means that you're still working. You don't fall within an exception because we never get that far. And that means that in each case, a tribunal would have to decide whether in the circumstances this sleepover shift should be seen as being work, in which case the minimum wage would apply, or merely being available for work, in which case it would only apply when you're actually called upon to do work. Now that, if you found that quite exhausting as an explanation, if that strikes you as quite obscure, that's one of the reasons that it hasn't worked, right? That was a workaround that has essentially been developed by the courts to get around this rather clunky provision, Regulation 32, as it now is. It was in various previous iterations in earlier versions of the regulations. And so what happened when this case got to the Court of Appeal? They essentially cut through that rather clever argument and said, look, to say that you're working while you're asleep is an abuse of the language. You're not, you're unconscious, you're not actually working. And they looked in particular at the Low Pay Commission in 1998, who had made it clear that sleepover shifts should be regarded as falling outside the national minimum wage. And the government had accepted that recommendation, which I'm going to go to in a minute. And that meant that you had to read Regulation 32, not in this clever way about are you working or are you just on standby because this is a deeming provision. But instead, you should just take the common sense view that sleepover shifts don't count as work, because that's what the Low Pay Commission said in 1998. So that Low Pay Commission, the recommendation in 1998 said this: certain workers, such as those who are required to be on call and sleep on their employer's premises, for example, in residential homes or youth hostels, need special treatment. For hours when workers are paid to sleep on the premises, we recommend that workers and employers should agree their allowance, as they do now, come back to that phrase, but workers should be entitled to the national minimum wage for all times when they are awake and required to be available for work. And you'll see that awake for the purposes of working has found its way into the regulations there. Now, I have some issues with this being called into this case, this 1998 regulation, because although 1998 seems a very long time ago, I do remember it. And I was working at the time in a trade association. I was working for the Chemical Industries Association, the CIA, head of employment law at the CIA, don't you know? It's the best job title I've ever had. And I was essentially lobbying the government on behalf of the chemical industry about the various employment law measures that they were proposing. And minimum wage was not a priority for us because chemical industry pays rather well. but I was on various committees that the CBI was running that was looking at how these minimum wage regulations were being developed. So I do remember this issue cropping up, and I do remember the very clear understanding that sleepover shifts would not attract the minimum wage. But you've got to remember that in 1998, the idea of a minimum wage was quite radical and controversial. Labour had been elected only in 1997, after years and years of Conservative government. The Conservatives, they're quite keen on the minimum wage now, but they were fundamentally opposed to it in 1998. And the Labour Party was very keen to present itself as acceptable to business. It was very keen to keep the CBI on side when it came to its employment law policy. And so when it came to this controversial issue, it tried to dump as much of the controversy as it could on a tripartite commission. They created the Low Pay Commission, which was made up of academics, employers, and trade union representatives. And it said, we will follow their recommendations. So when this recommendation came in to say, there needs to be special treatment for sleepover shifts, that was something that the government was certainly going to take into account. In fact, we'll come on to a moment later, they had to take it into account. But notice one thing about the wording. We recommend that workers and employers should agree their allowance as they do now. The assumption was from the Low Pay Commission that if you don't get the minimum wage for your sleepover shift, you will be getting an allowance. But there's no law for an allowance. There's no obligation to pay it. The assumption was it would be paid. This was 1998. This was the start of a golden age of social partnership, they thought. There was going to be a massive extension of trade union recognition, they thought. There was going to be new laws introduced that would make employers talk to trade unions. So the assumption was that these workers might not be protected by the minimum wage legislation, but they would be protected by their trade union bargaining on their behalf. And I don't think it's quite turned out like that, has it? But that's the context in which that was viewed, and it's very much not the context of the way things are today. Nevertheless, the Court of Appeal relied on it. The Supreme Court, they completely accepted that argument. They relied on it too. In fact, they went further and said, look, we can give real weight to that recommendation. Because if you look at the National Minimum Wage Act, Section 5, it actually commits the government. And again, this is the government of the day making the case that it's nothing to be scared of, and it's going to follow the recommendations of this tripartite committee. If following the report of the Low Pay Commission, that's the first report setting the level of the minimum wage, the Secretary of State, lots of things, decides to make regulations which in some other respect differ from the recommendations of the Commission, the Secretary of State shall lay a report before each House of Parliament stating the reasons for it. So the government was saying, look, the Low Pay Commission is going to make us recommendations, and we will follow those recommendations. And if we don't, we have to write a report to Parliament explaining why. Well, of course, they didn't write that report because they did follow the recommendations. But the Supreme Court takes that as meaning, look, that recommendation made by the Low Pay Commission that sleepover workers or sleepover shifts shouldn't count for the purposes of the national minimum wage, we can take that as being the clear intention of Parliament, because if it wasn't the clear intention of the government putting forward the legislation, it would have said so in a report. So so what might otherwise have just been a report by a Low Pay Commission from 30 odd years ago becomes very straightforwardly the requirement of the legislation. You may remember that in the Uber case quite recently, they interpreted the rights of a worker in line with the purpose of the legislation. So in a sense, what the Supreme Court is doing here is similar to Uber with a very different result, where they are looking at the purpose of the legislation in order to figure out what it means. And to be fair, Regulation 32 is badly and clunkily drafted, right? It doesn't read well. It does strike me as ambiguous. And so they're going for what they think is a reasonable view of it. So what does the Supreme Court actually say? Well, here what I've done is I've basically just taken what I think are the key bits of the judgment that Lady Arden has given and just highlighted them to just see how sweeping and clear what the Supreme Court has said is. So she says in paragraph 42 of the judgment, The contemplation of the regulations in relation to time work is that a sleep-in worker cannot actually be working for national minimum wage purposes if the arrangement is that he is to be present and sleep on the premises during his hours of work, subject only to emergency calls. Just a real straightforward, what the regulations intend. Let's not worry about your clever argument about doing work first and then figuring out whether standby is different. The regulations intend that a sleep-in worker doesn't qualify for national minimum wage for those hours, subject only to emergency calls. The fact that there are separate regulations or regulations with separate paragraphs does not mean that those regulations or paragraphs do not have to be read as a whole, right? So what she's saying there is your argument that before we get on to Regulation 32, we have to look at the definition of time work and figure out whether you're working first. And if you are working, we don't get on to Regulation 32, so it doesn't count. She just has no time for that. You say, no, you've got to read those provisions together so that they make a harmonious whole. You've got to look at the overall intention and read it together to take something coherent out of it. It's another point that's basically, let's not follow your clever argument. Likewise, the expression awake for the purposes of working is a single phrase. The word awake is not to be read on its own. I'd been talking about this case for some years, and one of the points I always made was, well, hang on, if you're only not covered when by the minimum wage when you're asleep, what happens if you have a bad night's sleep? Is the employer going to check your Fitbit to see what kind of night's sleep you've got and start paying you for the breaks in your sleep? Well, no, says Lady Arden, because it's not good enough to be awake. You've got to be awake for the purpose of working. And she says in a bit what she think that means. So if the employer has given the worker the hours in question as time to sleep, and the only requirement on the worker is to respond to emergency calls, the worker's time in those hours is not included in the minimum wage calculation for time work unless the worker actually answers an emergency call. So it's not good enough to be lying awake, even lying awake thinking about work. There's got to be something specific that you're doing during your sleepover shift for that to count as working time. And in that event, she says, the time that the worker spends answering the call is included. And in this aspect of the result, I agree with the illuminating analysis of the Court of Appeal. It follows that however many times the sleep-in worker is, contrary to expectation, woken to answer emergency calls, the whole of his shift is not included for NMW purposes. Only the period for which he's actually awake for the purposes of working is included. So what that says, I said right at the beginning that Miss Tomlinson-Blake was only woken up 6 times over 16 months. Lady Arden is making it clear there that that's not the basis on which she's made the finding. She's not saying it depends on how rare being woken up is. Even if you're woken up a lot, that won't make the whole shift count. Each individual piece of work you're called upon to do will count. So, if you did 8 hours of actual work, that would count for the national minimum wage. But if you were woken up 4 times every night, that still wouldn't make your sleepover shift count, because the expectation is nevertheless that you will be sleeping for most of that period. I'll talk a little bit later about whether there's any room for ambiguity there, any room for wriggle around work where you really expect quite a lot of work to be done over the course of the sleepover, where it might not be appropriate to call it a sleepover shift at all, but I'll come on to that. So that's pretty sweeping, to be honest, and it is pretty clear. There is an unused argument that was raised in Shannon. So the QC for Mr. Shannon, Casper Glynn, had raised this in the Court of Appeal, but it was raised in the Court of Appeal for the first time during oral argument. He wasn't allowed to put it, and the Supreme Court didn't allow him to put this point either, or at least they didn't consider it. One of the things he tried to argue is because Mr. Shannon had fixed hours of work that were 10 p.m. till 7 a.m., he said, well, those are the basic hours for which he's paid a salary, 10 p.m. to 7 a.m., albeit his salary is only £90 a week. And he argued that since they're his basic hours, we don't have to look at the sleepover exception, because the sleepover exception for salaried hours work is very clearly about additional hours. If you've included overnight as part of your basic hours, if those are the hours for which you're employed, it shouldn't apply, and you should get your normal rate of pay, or you should get the minimum wage for those hours. I have to say, I sort of think that's right. If that's the way you've drafted the contract and they accepted that this was a valid contract, then I think logically that must be correct. The Supreme Court didn't allow him to put the argument. They said it might require, apart from anything else, new factual findings of the tribunal as to what the basic hours were. I suspect actually that the way the Supreme Court has dealt with this, we've got to look at it as a whole, and let's not look at one bit separate from another bit. There's still a sense in which arguing that the basic hours have to be counted first and then the additional hours, and it's only there where the sleepover shift comes in, well, that might fall foul of the same argument that the Supreme Court raised. So I wouldn't raise out a lot of hope, but technically that's an argument that's still open for someone who is salaried and for whom those overnight hours are scheduled in as part of their basic hours rather than being an additional shift that they work. Now, so far on everything I've said, what the Supreme Court has said is completely unanimous. They all agree with each other. So the 4 justices all agree with all the points that Lady Arden has made, right? So it's a very clear judgment to that extent. There is a case that they looked at called British Nursing Association against Inland Revenue from 2002, which essentially kicked off a lot of these issues. And it involved call handlers, basically people working in a call center who worked at the call center during the day, and then they would have shifts at night where they went home and had to do a call. It wasn't a call out exactly, but their phone would ring at home and they'd have to answer and sort of pretend they were still in the call center. And the Court of Appeal held in that case that they were working throughout their evening shift because sitting waiting for the call to ring at home was no different from sitting waiting for the phone to ring in the workplace. Well, the Supreme Court has held that that can no longer be relied upon. But the Supreme Court judges don't agree on why it can no longer be relied upon. 2 judges would overturn it completely. 2 judges would say, well, it needs to be thought about again because it wasn't a very satisfactory case and it's no longer authoritative. And so that leaves some doubt as to what you would do with people who have an intermittent job, right? The justice coming away from people who are expected to sleep and people who have got a standby job where they might be working at home, and bearing in mind how many of us are working from home now and how many people are working remotely, it leaves some doubt about how you would handle people whose tasks might be intermittent, like, for instance, only answering the phone when the phone rings. Are people going to start arguing that if you're answering calls in a call center, you're only working when you're actually answering the phone, and you're not working when you're sitting there waiting for the phone to ring? Now, to be fair, the Supreme Court justice didn't rule that that was the case. Their case was very much focused on people who are expected to sleep over the course of the shift. But they've opened up the question again, I think it's fair to say, and we're going to need tribunals to look quite critically, I think, at employers who are trying to wheedle their way around this ruling and trying to not count things as working time that should really be counted as working time. To be fair, at least 2 of the judges in the Supreme Court did talk about how intermittent tasks can still be a continuous period of work, and you can still be working for a whole shift even if you're allowed the occasional nap. So, you know, if there was a quiet period and you said, you know what, nothing's happening for a while, I'm just going to go and have a bit of a sleep, if that was regarded as okay, you wouldn't necessarily stop working when you went and had a bit of a nap. This case is about a sleepover shift where the expectation is that it's an overnight shift that you're going to sleep through unless you're woken up by an emergency. Now, I think there might be some wriggle room. There might be some arguments about the difference between those 2 situations. So I can envisage quite a lot of case law coming out over the next few years about intermittent working and work where you have to keep a watchful eye on something but only intervene occasionally. And especially when you do that at home, how does that affect your minimum wage entitlement? I think we have to say we're less clear on that than we were at the start of the day. What next? What actually comes next? Well, I think the first point to make is that there is no way of challenging a decision like this. It's called the Supreme Court for a reason. I haven't particularly tried to critique what the Supreme Court have said, partly because I've only read it a couple of hours ago, so I think it's a little early for it to have digested that well for me. But there will be academics and there will be plenty of people who will go through it with a fine-tooth comb and find things to criticize in the way the Supreme Court's approached it. But there's not a lot of point in doing that, because that is what the law is now. You can't really argue with the Supreme Court decision. I think a couple of things I'd stress. First of all, remember that the low pay commission policy that has been relied on in this case to mean that these people can't get the minimum wage on the sleepover shift, that policy was that sleepover shift should attract an allowance. But there's no law that gives them an allowance. So although the Supreme Court was working in a context where they're thinking about workers being compensated by an allowance that doesn't quite match the minimum wage, and Ms. Tomlinson-Blake got an allowance, it didn't match the minimum wage, but it was something. The consequence of their decision is that care workers are not entitled to be paid a thing in respect of those hours. They can be required to do them. They will still be regarded as work. They're still regarded as working time, for example, for the purposes of the working time regulations. There's no doubt about that. So if you're on the sleepover shift, you are certainly working for the purpose of your 48-hour week. You're entitled to rest breaks, which might seem slightly odd in the context of sleeping through the night, but there you go. But there's nothing that says you get paid a thing in respect of that time. So there's a strong case, I think, for the law to be changed. Either we could amend the minimum wage regulations to make it clear that actually sleepover workers should get the minimum wage for those hours, or we can have something that says they should at least get an allowance, which is what the TUC was calling for in 1998. The problem is that that's no longer a matter for the courts, right? That's a matter for Parliament. We can debate whether the government is likely to be sympathetic to that sort of policy argument. We can debate how long it would take them to get around to it. It's a matter for trade unions, right? It's a matter for industrial relations. If I was going to advise care workers who are worried about this decision of one thing, the one thing I'd say is join the trade union. Because what this case demonstrates, I think, is you can't just rely on the courts to protect your rights or to enforce your rights. It can only really be done by very clear laws or very clear trade union representation, where you've got some heft with the employer and then can insist on proper bargaining, where you can actually bargain to get the appropriate rate of pay. So that's the nearest I've got to a conclusion out of all of this. I don't think I've got very much more to say on it. I'm very happy to take any questions that are coming through. Okay, interesting first question. If a company had started paying national minimum wage because of the previous decision, is there any way they can go back to no pay? No conditional offer made at the time? Well, I think that's a really important point. If what you've done is, because over the years it had seemed clear that people were entitled to the minimum wage on the sleepover shift, if that's now become part of contracts of employment, so the written statement of terms and conditions says you will get the minimum wage for this sleepover shift, well, that's a contractual entitlement. And if the employer wants to change that, it's going to have to do that in accordance with the rules on changing contracts of employment. So it's got to get an agreement somehow. What it may do, of course, is dismiss and re-engage on new terms if it felt it was that important. It's not going to look good if it does this. I mean, of all the changes that you could make to care workers at the moment, and bear in mind the year that care workers have had, if you're a care provider and the first thing you do in response to this decision is try to change terms and conditions of employment so that workers who were previously getting the minimum wage will now get less than the minimum wage, well, no one's going to be your fan. That's not going to be a good look. But that doesn't rule out it happening, and it doesn't rule out them being able to change the contract through that mechanism. But what I would certainly agree that I don't think they can do is simply decide, oh, all bets are off, we're now going back to the position we had before, unless the change they made was very specifically, as long as we are required to pay the minimum wage, we will pay the minimum wage, and we will comply with this judgment. If that was all they were saying, then possibly they haven't made a contractual undertaking. But if they've actually gone further than that and said, this is how we pay people, well, I think that's probably a term of the contract now, and it's not something they can just go back on. And the next question, do you think this decision is at odds with the recent Uber decision, where all time logged into the app counts as working time for national minimum wage purposes. Yeah, it's a possibility. I think there's some ambiguity around exactly how working time would be calculated for an Uber driver on standby. It's certainly true that the Supreme Court held that the tribunal was entitled to find that their standby time counted as working time. But they did that on the basis of some fairly vague facts about the driver being ready, willing, and able to work and holding themselves as ready. It's not entirely clear that that's going to be the same position here. But in any event, this is about a specific exception, right? So this isn't about whether sleepover would, in the absence of anything else, count as working time, right? If there was no Regulation 32, if the Low Pay Commission had never made that recommendation, then maybe the Supreme Court would have held that sleeping overnight counted as working time, and that would have been consistent possibly with the Uber decision. But they're relying on a very specific exception, Regulation 32, which says a sleepover shift shouldn't count for the minimum wage. And that's based on the recommendation by the Low Pay Commission that was accepted by government when it was drafting the legislation. And that's why they're not getting the minimum wage. It's not because the Supreme Court thinks there's something inherently wrong with the idea of working time being when you're asleep, although Lady Arden does mention it's an abuse of the language to mention she's sympathetic to the idea that it seems a bit odd to be regarded as working when you're asleep. But it's a very specific exception we're dealing with here, so I don't think it conflicts with the Uber case. Sorry, I had to talk myself around into thinking that, but there you go. Another question, I understand that some employers paid back pay following the EAT decision. Do you think an employer could seek to recover that in light of today's decision on the basis it was paid in error, as there was no entitlement to it based on the Supreme Court decision? Well, if it was based in error, and apologies, do not rely on this as any form of legal advice, because I'm answering this off the top of my head. I believe that a legal error, if you overpay someone as the result of a legal error, that's not recoverable at common law. That's not recoverable as an overpayment. It's only if you make a factual error that your overpayment is recoverable in principle. So if I paid you overtime because I thought the contract required that, that's an error of law and I don't get that back. But if I paid you overtime because I thought you worked on Sunday and you hadn't, then I might be able to get that money back. As I remember it, it's a while since I looked that sort of thing up. But in that sense, that would mean that no, you couldn't recover it because it wouldn't technically be an overpayment that you could recover. That's what you get when you just make your payment before the Supreme Court makes its decision. So I think that would be the position. But heavens check. Don't rely on me saying that just off the top of my head. Are there any other questions from anybody before we finish? Okay, well, excellent. Well, thank you for joining me. Look, can I say a couple of things? First of all, have a look on my website and see some other webinars that I'm doing. One thing I will do is cure the strange flicker in my screen that I seem to have seen. I'll figure out what's going on there before I do any more webinars. Also, can I suggest if you go on question, is the case going to be appealed further? No, there's no one to appeal to. It's the Supreme Court. It's the end of the road. This is the definitive answer to the question. There's nowhere else to go. I was going to say, if you are on Twitter, have a look at the tweets that are coming through on this. There's a lot of really interesting discussion on it. I know there's a blog that's been posted by Cloisters Chambers, by the barristers that were involved in the decision. There are also some interesting threads from some of the barristers involved in the decision. So do watch out at the hashtag UK Emplor to see all the various things that are being said about this case in those circumstances. Apart from that, thank you very much for joining me. Commiserations if this was not the decision that you were looking for, but bear in mind that ultimately these things, you know, there are just other means that you need to follow to reach your objectives on these things. And hopefully I'll see you again at some other employment law thing or webinar. I hope to see you join me for something else. Thanks very much for your time. Have a good weekend. Cheers.
Thanks for watching. I'm Daniel Barnett. Please do subscribe to this channel and click the notification bell. And here's another video you might like. Bye-bye.